And good afternoon. Welcome to today's delayed Facebook Live. Minor technical difficulties here today. That's why we're lawyers, not IT people. Anyways, I'm attorney Michael Bender.
Oh, and I'm attorney Allison. And this is live. And we are the Gray Legal Group.
All right. Well, just a reminder, the information in this video is for general purposes only. Nothing should be taken as legal advice for any individual's case. The information is not intended to create, and receipt of viewing does not constitute an attorney-client relationship. With that, question number one, do we do rock, paper, scissors on this one? Was it you?
Yep.
Okay. Can an ex-spouse take custody of a child and relocate to another state? We live in California. My wife wants a divorce and move with our daughter to live in Florida. Can she do this legally? That's the question.
It's a really broad question. Okay, so it doesn't look like anything's been filed yet in this case because you want to file for divorce. So if you fulfill the jurisdictional requirements of California, this is not funny.
And the wife wants to file for divorce here.
Well,
sorry.
Okay, case gets filed in California. Assuming that California has jurisdiction over the child, the case is in California. And if your wife wants to take your child out of the state of California, she has to file it's a request for order asking the court to grant a move-away request. And that's what it is. It's asking the court to give her the ability to move out of state with a child. And those requests are frequently filed in the courts, but they are very, very difficult requests. They typically take at least a year before an order is even made in the case. You file a request for order, you get sent to child custody recommending counseling, you have a hearing. It usually involves a custody evaluation, which I think we've discussed in other videos. And then you go back to court on the custody evaluation, and then sometimes it totally accumulates into a trial on the issue of whether or not a move-away should be granted. But short answer is no, you can't just move, because once the divorce case is filed, children can't leave the state of California, but she could ask to move away. That's it?
That covers
Anything?
that.
Anything
No,
to add? All right.
Not today.
Thanks. So we've got another question here that Michael's going to answer for us. If I file for legal separation, can my husband file for divorce and fight for custody? My husband and I moved from California for only a few months, and I moved back and filed for legal separation in California. My daughter only lived in the other state for 3 months. If he files for divorce in the other state, can he fight for custody in that state?
You know, when you were answering the question to the previous question, it was actually a good segue into this one, because you said if California takes jurisdiction, and this question is all about jurisdiction, which state is going to have jurisdiction. All states have adopted the Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA for short. What that law basically says is the home state of the child is going to be the one that takes jurisdiction over making custody and visitation orders. Home state being where that child has resided for a period of 6 straight months. Here, there's been mom moves back, lived in the other state for only 3 months. The child has not resided. The other state is not going to be that home state. There is one caveat to that. If there's an emergency jurisdiction, there's nothing in here that says dad might allege the other state could take jurisdiction or based on an emergency. Did mom move back without dad's consent? All sorts of things could initially be looked at as emergencies. However, ultimately it would come down to the states or the judges in each state holding what's called a UCCJEA hearing, where both cases are called over speakerphone, and the judges essentially determine what's going to be the proper venue for that. So it's possible, but likely in this scenario, California is going to be the home state of the child, and California under the legal separation is going to be custody visitation. Anything to add?
The only thing I would add to Michael's excellent answer is that if your husband, soon-to-be ex-husband, files for divorce in the other state, you cannot ignore that petition. You have to respond to that petition, and you need to let the court know that you have filed for legal separation in another jurisdiction in California. Otherwise, you could end up with a judgment by default in the other state, even though you're actively pursuing your California case. So if there are two pending cases, before that UCCJA hearing can occur, it has to be some type of response to his underlying petition.
Absolutely. Never ignore anything that's filed, even if it's within another county in California. Everything has to be addressed. Well, I want to thank you for joining us on Ask a Lawyer. Join us each week as we discuss family law issues important to our community. If you have a legal question that you'd like us to address, go to thegraylegalgroup.com and click on Ask a Lawyer. We'll see you here next Tuesday at 1:30.